You started the process, and with this judgment, that's going to speed up the process. And you know, Ghana, we have various laws. You can choose to stay away. But so far as you have laws relating to how you can extradite from one country to Ghana, in case there's a judgment against like this one, rest assured that should be brought down to face justice. When it comes to extradition, sometimes you start and have some kind of problems, blocks. The person may choose to appeal and all manner of things, but this is the situation where we have final judgment. It's not as if you are being brought here to be tried, or you can raise all the defense out there that maybe they are going, they're persecuting or whatever, but it's a judgment. And so that's why I said you hold on. Very soon to be brought down to Ghana to face justice. This one is a form of advice and caution to all public office holders that when it comes to money matters, you must be very, very careful. You may want to say you receive only 20,000 Ghana cedis as a gift. Were you supposed to receive that money? What was that money meant for?
Well, so that's Alfred Tuah-Yeboah. Gentlemen, that's Alfred Tuah-Yeboah, who's the Deputy Attorney General there. After the ruling of the courts, former Chief Executive Officer of the Microfinance and Small Loan Center, Sedina Tamaklo Ationu, sentenced to 10 years in prison with hard labor. Also, the former Chief Operations Officer, MASCLOC Daniel Axim, also handed a 5-year jail term with hard labor. The two were found guilty on 78 counts relating to causing financial loss to the state, theft, conspiracy to steal, money laundering, and contravening public procurement laws. Trial began in 2019, saw 6 witnesses called by the state. Sedina Tamaklo was tried in absentia as she, according to the court documents, absconded and after obtaining court permission for a medical checkup abroad. Daniel Axim testified in person, did not present any witnesses. The convictions stem from misappropriation, and we'll put some of the brief facts of this case on the screen right now. Misappropriation of funds allocated to MASCLOC activities between 2013 and 2016. In fact, in one instance, the convicts withdrew 500,000 as a loan from Obatampa Savings and Loans Company, demanding a refund when the situation, in fact, the institution refused to provide a 24% interest rate. Although evidence of the refund was presented, it was not reflected in the MASCLOC account. The two also found guilty of misappropriating over 1.7 million cedis allocated for a sensitization exercise, with only a fraction of that funds used for the intended purpose. Similar funds disbursed for victims of a fire incident at Kantamanto were also not fully distributed, with a significant portion misappropriated by these accused persons. So, in fact, that's what we have now. And Amakwa, you have the full judgment, and this causing financial loss to the state, and how this case has traveled from 2019 till this moment when this judgment was delivered. In ensuring that this 10-year jail term is applied, what processes would be employed, especially because Sedina, for instance, was tried in absentia?
Thank you again. I need to lay the foundation about this trial in absentia. I've seen on some platforms that someone from my brother's party, and I don't think that would be the position of the party itself, that because he was tried in absentia is a miscarriage of justice and didn't give her the opportunity. I think Article 19.3 of the Constitution takes care of that. And it says that, if I may just glance quickly through it, it says that a trial of a person charged with a criminal offense shall take place in his presence unless he refuses to appear before the court for trial to be conducted in his presence after he has been duly notified of the trial, or he conducts himself in such a manner as to render the continuation of the proceedings in his presence impracticable, and the court orders him to be removed for the trial to proceed in his absence. So this is the foundation, constitutional foundation, of course, in the criminal procedure. There are provisions there. And if you look at page 38 of the judgment, and I drove my heart out to Leadership Justice Efiasewa J.A. I think she's a very thorough person, and you can see that in her judgment. She recounts all these instances where she had come to be granted her passport, so she goes for a medical checkup, and she gave her time when she will come back, and the case has dragged until now. So I think those are covered, and I want to sound a caution that when we don't understand judicial proceedings and we put political spins on it, it doesn't help the discussion. Okay. So back to the issue of what should happen. I think there are issues of extradition. In fact, the leadership talked about that the executive has not taken any step to make sure she comes and accounts for that. And then the deputy AG said that they are taking steps to do that. And I think that is proper, so that, one, you see, the conviction is that of a high court decision. If she wants to challenge it, she has a way of appealing it within 3 months of the rendering of the judgment, and even 3 months after that, she can bring an application to say that for this and that reason, the time should be extended for her to appeal and all that. She can travel all the way to the Supreme Court. So she shall avail herself of that if she thinks she is not guilty, including the second accused person must avail themselves of that. If they don't do that within the next 6 months, then the door seems to have closed on them in respect of appealing. Sentence, it is very easy to think that we can just speak to Interpol and the other, I think she's in the United States, and speak to the authorities in the United States, and then they'll bring, no, we have to go through a process. There's a process for extradition, which is also another legal process. And then I have done one where someone was extradited from here to the US, for instance. And if you go through court, you go to the High Court, you raise human rights issues and whatnot. And then the idea is that if the person going to the other country will not face justice, then the person should be stopped from taking to the other party, the other country. For instance, in UK, I did one where the person was seeking asylum. And then the idea was, and the asylum was denied. The idea was that for the person to be taken back to that country, or one of those war-torn countries, when he gets there, he'll be executed. And so those are issues you'd raise. And so yes, the Attorney General knows what to do. They'll go through that.
But could this process have started while the trial was ongoing? Because that's one of the issues the judge raised, that why didn't the state start this process of extradition until this moment that the judgment was delivered?
The Attorney General's Department may have reasons for that. And what I want to establish is that it is not lost. It's not a lost cause that because she didn't take part. Remember, it is her, she has the inherent duty to make sure that she's come to prove that she's not guilty. Okay? And so, absconding, so to say, and the judge was particular about the absconding, so to say, doesn't mean that the process cannot continue. It is that she has lost the chance to come and stand in the box to prove or to make sure that one element of, say, stealing or about 80 charges, 80 counts, one of them, some of the elements are not present, and therefore she should not be found guilty on those counts. It is for her to come and do the same, all right? But at that moment in time, it is the prosecution's duty to ensure that they establish the crime, the ingredients of the crime, which they have done successfully in the view of the court. And at this moment in time, we can all say that they've established that successfully. It is for her rather to come and disprove and to make sure that her position is canvassed so that she is found not guilty. It is not the other way around. So it's not to say that without her being there, they couldn't have done their job. Without her being there, if they couldn't find some evidence without her involvement, then that would have handicapped the prosecution of the matter. But where it has started, if you read it, she had been part of the proceedings, CMC level. He had gone through, I think, 1.5 years before she came up with the medical issue. Then the court can proceed. The prosecution in India would have had all they needed to prosecute the matter. So remember, there's conviction, there's sentencing, then there's serving the sentence. So the two has occurred, conviction, sentencing. It is in serving the sentence that the AG is now saying that he's taking steps to ensure that she comes to serve it. Otherwise, each time, any moment in time when she arrives in Ghana, it starts from there, because then she wouldn't have served. So if she takes 20 years and she comes, at the moment when she ends up at any other port in Ghana, then it will start from there.
It's about the money involved as well. Apart from jailing her, processes to retrieve the money as well in the interest of the state. Yes.
Remember they said, in fact, the judgment says it takes account of her properties. All right. So it's for the AG to bring. It's all a process in court where you have to come and attach and then realize and all that. And it's very easy to think that it just happened like that. There's a process. She has lawyers. They will come and do what they have to do before it is realized. And then the fact that it is realized doesn't mean that it is converted into a liquid state where the money is coming to. It may be a property that needs to be sold, and then you sell it, it can remain on the market for a while. You may even have to beat the price down. So there's a whole process that this involved.
See, people earlier when we spoke, you mentioned that even the prison conditions in this country can be one of the issues that her lawyers could raise or against this extradition of she coming back into the country.
Yes.
There are prison conditions.
Yes.
If she's able to prove that the prison conditions are inhuman, then it could impact on the extradition.
Absolutely. Absolutely. Let me tell you a bit more about that case. We did a case, so I won't mention the name of the accused here. Professor Tifa, it was Professor Tifa's case, and then he took me on board, so I had to render a bit of assistance. We went to Ankafo to look at the prison conditions in Sawam, etc. Then Atifa did this report. He had to go to the UK, was in the House of Lords of which court, to testify, right? At the end of the day, the prison conditions didn't meet the standards of the UK authorities. So the guy won. He wasn't extradited. Yeah. Our prison conditions are terrible. They are terrible. And I'm surprised politicians, left, right, center, they don't do much to improve the situation. And yet, they are the people who are so good at it.
So the prison conditions can be a potent argument against this extradition.
Absolutely. Look, at the UN level, they've discussed. There are several reports that go against us in respect of our prison conditions, overcrowding, etc. So there's Justice Hometou. Yeah, when he was High Court judge in Sawam, he would use the UN reports and, as part of the mitigation, reduce the sentences, because that is law. You can't subject people to so much inhuman condition that, yes, the fact that they've committed crime doesn't mean that apart from serving the term, you should subject them to inhuman conditions. Article 15 of our Constitution is against that. Yeah, we tried something in the Supreme Court, but eventually the Supreme Court said no, they will not take the matter. We should go and go to the High Court. But it's terrible. It's extremely terrible. And maybe before your next question comes...
and I want to conclude, Lawyer Malcolm. This was just a quick contribution. The Deputy Attorney General says this particular case should serve as a lesson to politicians and government workers. I mean, you are not. Are you a government worker?
No, I'm not. I'm just a law lecturer and private legal practitioner.
But it's certainly a reference point for some lessons.
He's waiting for in case Baumia comes.
Anyway,
but he didn't get a chance.
They're doing my job for me. Thank you very much. If you feel like qualified for that, I believe I do. Thank you very much.
That would be
so get to that point.
You wish. 2025. 2025.
Okay.
You wish. Yes. Now, you see, when we went to first year, then we all had to come and give oath that will comply with the school's regulations. And it will end by insta to populari, is that also? In this whole persons, all of us gathered, we are doing so in our own personal capacity. And I think that's what should guide everyone. And today is on the left foot. The next day may be on the right foot. And so everyone should be guided by this. And so what he said is proper, is germane, that this is advice to any official of the state. Because you see, we have one Ghana, we keep on saying, we cannot mess it up and then hope that, and if any court anywhere is going to use the conditions of our prisons to deprive anyone from being extradited, I don't think it would. They should also look at the context within which Ghana is situated and say that this is the Ghanaian kind of prison, and so you cannot say that you want it. You want it because there are prisons there. There are prisons there that is one in a room with TVs, with their own TVs and whatnot, and all that. I mean, we cannot say that where Ghana has reached now, we should elevate our prison system to that extent. So if you don't meet that, then the person cannot be extradited. So I think it should be looked on case-by-case basis.
Okay.
It is, I mean, even without him saying it, that is a caution to everyone. I think everyone should know that it's such a popularity. You go there as a person, as a group, make all the and as my brother is doing in Parliament and whatnot. But it is you, the person. I remember in the same Efiase was court, just Efiase was court, when I think I was a year ago or so. His matter came there, I was in the, we had just finished our case and they called that, and I sat down. And then someone said he's busy in Parliament and whatnot. Efiase said, in my court, I give him 1 hour. By this time, if he doesn't appear, we will see what will happen. I don't know how the message got to Parliament. As I got down, then it was his third floor, it's not second floor. Financial division, Court 2, second floor. I chatted for maybe 5 minutes. By the time I got to the foyer of the front of the court, I saw all MPs coming. All the MPs who are lawyers coming from Parliament. And then I was a Canadian for. So he asked, what are you guys going to do? If yes, that is judicial power. That is what we want to see. It is not always the you see, executives are executing. So they are the visible ones. Parliamentarians are always making, and there are a lot of issues happening in Parliament now. But there should be the exercise of judicial power. One is brought to them and make sure the right thing is done. And so I think we should all take note of this and make sure you don't find yourself on that, because it is in such a popularity. Indeed. You go in the best you can do. I remember when Woyomi was in prison, NDC MPs trooped. I have issues with that because I think it is not a sense of solidarity. It's about the state. But they trooped. At the end of the day, they went back, and he was the one left there. You see, so I think we should be careful about
and
this.
And whenever I say that, Martin Bebo, probably you don't blow your trumpet enough, and well, maybe some of us will have to do that. At least with the impact that you've had on our jurisprudence in this country, with you going out of your way to test the law and refine legal procedure. Anybody who sits in any lecture in the law school, your name comes up every now and then. Had it not been for you, maybe the persons who stood surety for Sedina Tamaklo would have probably been in jail by now.
Absolutely.
So I'm talking about Alex Mould, the former GMPC CEO, and then also Gavivina Tamaklo, formerly with the National Theatre. They stood surety for Sedina Tamaklo to be granted this permission to even travel for this medical attention. 5 million cedis bail was what was put on their heads. Prior to lawyer Martin Pebu testing the law in Pebu number 1, these people would have been imprisoned. Is it
Extrinsic of bail?
No, that's
not imprisonable.
And lawyer,
that's Pebu number 1
at this point.
Before we go to number 2, number 3, number 4.
This is what would have happened.
Yes.
That these two who should stood surety, because Sedina Tamaklo is said to have absconded, they would have been thrown in jail.
Absolutely, for 6 months. So that used to be part of Section 104 of the Act 30. Yeah, that was part of it. The jail term was 6 months. So when I presented that case to the Supreme Court, they dealt with it in February, and then by December of 2015, the decision came out. December 2015, sometime December 2015, the decision came out. So the Supreme Court struck down that subsection of Section 104. I think it's subsection 6 or so. Yeah, one of them down there. Yes. So Mr. Alex Mould, Mr. Tamaklo would most probably have gone in. Because if you can't produce the accused person, then under the law, you would have gone in. But where that was wrong, because under Article 19, Clause 11, you can't just turn that into a crime. So you see this in the ECG, the PURC report. Yes, you must specifically create a crime in the law against somebody before you talk about imprisoning the person. But signing a bail bond is not a criminal conduct. There is nowhere that is stated that if you sign a bail bond or you stand as surety, or I prefer the word guarantor, since guarantor is more popular, more people have taken loans, and so they can easily remember guarantor. So if you guarantee for somebody on a bail bond, the person absconds, there is nowhere that is stated that the person absconding constitutes or your failure to bring the person to stand trial constitutes a crime. That's the main thing. That's the easiest way to understand it. There is nowhere in the books that they've created such a crime that, hey, Mr. Okansi, if you guarantee for somebody, then he gets a bail and he absconds and you can't produce him, that is a crime. There isn't something like that. So the Supreme Court looked at it and said, oh yes, they would strike down the law. And since then, we've not made amendments. You see, Ghana, that's the problem. There are other ways of dealing with this matter, but it means that right now we have chosen the civil path. Because the bail bond is a contract. When you say bond, a bond is a contract, right? So look into the contract and go by the terms. So under the terms of the contract, if you sign that, you pay 5 million. I understand this Sedina Tamaklo contract is 5 million. So it means that Mr. Alex Mould and Madam Tamaklo, the other Tamaklo, will be facing the law. I even thought that side had been dealt with. Because, you know, at a point, Alex Mould used to attend court, and it was in the newspapers. So I thought they had distributed the bond. But it appears it's not been done. So it means that very soon, Mr. Mould. But he should thank his stars, because paying 5 million is certainly far less injurious than going to jail. And, you know, yeah, because under the old law, that would have been 6 months.
So it's good. I've used the old law where I argue this point without you going to the Supreme Court. So that's why, because if you look at Broby's book, it says that it is a contract.
Yes.
So owing doesn't convert into a criminal offense.
Excellent.
And I use that in the guy that was alleged to have signed the energy minister's forged his signature, remember?
Okay.
In I think it was Kofi Boa's signature. And a person, and someone stood for bail, and the person absconded. Sorry, the accused absconded. And I used that, and the person just had to pay for that.
Well,
and so it's always been,
so I just
for me,
to say
that's always been the case.
Thanks to you, Lawyer Martin People, at least there's been some improvement in jurisprudence. Thank you.
I thought you would give me an opportunity to have a bite on this.
Yes, you will.
I know I'm not a lawyer,
and talk about the takeaways from this as well, as serving as a caution to all public officers and politicians and government officials for that matter.
Yes. Yeah, absolutely. It's a chilling reminder to President Kufuor and his ministers.
To everyone.
Yes.
Not the
I said, I use the word especially. All of us. I've granted interviews when I said all of us. But right now, they are in the saddle. They have access to our funds. That is not to say
that things are happening before then.
Lawyer.
It is not subject to.
Yes.
Okay.
So,
for President
Kufuor,
we will talk.
For President Kufuor, you know, what I'm looking for is that when he leaves office, I'll be making a complaint so that we'll prosecute him for the over 500 million we spent on the fumigation of schools, etc. after COVID, when it wasn't necessary.
Right.
That's the investigation Manasseh did and won this, what do you call it? Is it West Africa Journalist Award sometime last year?
So you take him up on
Kufuor, now we will see. See, just like Donald Trump is before the court, Kufuor will also go before the court.
I'll hold you on to the work.
Over 500 million.
You think based on Manasseh's work
Yeah,
the ingredients are there.
Yes, the assembly said
I
that.
doubt.
The assemblies opposed it. They said there was going to be financial loss. They didn't think that fumigation was necessary. Yeah, why would
so making a decision?
Yes.
So I don't want to even get
I don't.
And for Bawumia, we will be doing the PDS. We'll be doing the role he played in changing the clause from a bank guarantee to an insurance guarantee. Next year,
you will be alive.
I bet the brutal next year.
You mean 8 years after today?
No, next year.
8 years after today.
Oh, you stand and see. You go before the court.
You know what we do?
Before the court.
We keep records on this show.
Yes.
As you have said.
Oh, yes. Oh, that report.
You.
Just like
you say you will go to court.
Yeah, and that reminds me. You know, CID. We reported this Galamsey matter.
Okay.
We reported Chairman Wuntumi about a year and a half to the CID. Abu Jinapo, Minister for Mines and Energy, says that
Lands and Natural
Resources says that Chairman Wuntumi Bernard Nchibosiako did not have a mining lease. CEO of Minerals Commission Martin Isi says Chairman Wuntumi did not have a mining lease. Yet he entered the Tano Nimri Forest. Until date, Madam Fosnando Kofi, CID boss, is playing games with the case. Look, Madam Kofi, if you can't do the case, leave. Leave. 1.5 years. When ministers, you see, for Abu Jinapo, an appointee of Ekufado to come out and say, listen, Chairman Wuntumi had no mining lease. For Martin Isi, an appointee to also come out. It should tell you that the thing is indefensible. Yet Madam Ando Kofi, CID boss, is just playing games with it. Just like the way Mamitiwa did to us when the case of Abu Jinapo and Asensuochi was reported to them. He called A+ on phone and was now negotiating.
None of them are here. None of them are here.
Let me have
the non-lawyer will have to. So, first one, they say, I think that, look, for me, the general principle is that if you go against the law should take its own course. And so it was within the rights of the Attorney General to have prosecuted this case. My understanding also is that, look, in the course of she demonstrated that she was not well and needed further treatment. The understanding I equally have is that, look, was there, said that her condition was getting worse. And that's why, and the lawyers tried giving, evidence to suggest that this was her situation. I believe the judge would have placed judgment value on the reports that had come, and on the basis of that, took a decision to make. I'm also told that those issues were actually also debated, appealed on, and it was at the appellate level. So I know the law will take its own course, and hopefully, at the end of the day, she'll be given the justice that she deserves. But my part, the angle that I'm interested in is that, you see, the alacrity with which this case was dealt with, and they went through and they were so committed to it. If you compare that to other issues that have come, that to an extent, we do not even know where we are. I use the first example. The example of Cecilia Dapa. You see that over a period of time, our time was wasted with OSP for God knows how many months, only to be told that he didn't have jurisdiction to handle that. And the thing had fallen now on the laps of Mamitiwa as a Yoko boss. Nobody knows where this issue has gotten to.
Thank you.
And the state is not interested in that. If you look at the figures that we are looking at with Sedinam as compared to this, if the fundamental thing is to make sure that the monies that are meant for the public good is preserved and other things, this is an area we should be looking to be interested in.
Okay.
The issue of Bisu, what's his name again? Charles Bisu, on the analysis expose on changing of, that Galamsey issue. Nobody knows where the issue is just left, right, nobody knows. Look, there are some of them. And I give you a typical example. The issue of the Australian visa scandal. Not only were the people brought back from Ghana, there was a report by the same government that indicted, the person involved. But you know what has happened? The government has gone beyond that to even reward the person by appointing him as a chief executive of an authority.
Yeah, pious.
All right.
Yeah, pious.
All right.
So I am just telling you that, see, I agree. Look, and all of us, just as the judge said, let's all be cautious. When you are given the opportunity to render public service, be very transparent and accountable, and ensure that you work within the limits of the law. But in doing that, because you lawyers, you have been saying that it is is a discretionary power that is given to the Attorney General to either prosecute or not to prosecute. Is that what you say? But the Constitution also still talks about the fact that in your decisions, it shouldn't be capricious or other thing. You shouldn't be seen to be that depending on the person's face. That is the basis under which you use in prosecuting.
Edward Bauer is Member of Parliament for the Bongo constituency. He is a member of the Mines and Energy Committee of Parliament. I appreciate you coming. Martin Kwebo is private legal practitioner, and today again I say thank you to you for all your sacrifices in improving the legal jurisdiction we have in this country with your Kwebo number 1, 2, 3, 4. Thank you so much for joining us. Lawyer Marco, I appreciate you for coming. Thank you. Thank you. Also, Kojo Poku, also thank you for joining us on Zoom, and also Ben Boache, Director of Africa Center for Energy Policy, also to Lawyer Richmond Roxon. Thank you very much for the messages, and then also the about 1,800 of you who sent us messages. Thank you so much for sending us your messages. On behalf of the rest of the team, I want to say thank you very much for joining us here on The Key Point. We are back next week, and this morning I was